Thank you, Farheen. Okay, well, it's late, so I'm going to give you a wake-up call. Because you're all sleepy, I'm sure. So, as I mentioned, I'm a business consultant with a foundation in corporate securities law. It's you never can wash off the lawyer in you. First 15 years of my career practicing as outside counsel with a global law firm. Next, I hate to say it, I know I've only been practicing 15 years, but the next 20 years as an entrepreneur in various businesses, including the telecom software business I mentioned, then in investment funds, and then in buying cargo ships and leasing them out, cargo ship funds, and I have liftoff. And so what I'm going to do for you, I want to give some credit to Justin Shelton, who is a dynamic young man at SMU Law. He's a law student, did a lot of the legwork to prepare an extensive Excel spreadsheet on all of the litigation and enforcement that we could find in blockchain and cryptocurrency to date. The point of this presentation is to create some awareness to you so that you might be able to, as you're building your businesses, navigate around some of the issues that are being raised and find that you might escape some of the short-termism of the tokenization space and think about the fact that if you're going to spend your time building a business, you want to be in business for a while, right? As Constantine said, I agree with him. I think that there's a 50% chance of a fairly complete collapse in cryptocurrency by this fall, and probably 100% chance by the next presidential election. But that will not end the value of blockchain and cryptocurrency and its uses, and you'll start to see what'll happen. Okay, this says, I'm not your lawyer. You can't conflict me out of any lawsuit I may take against you, even though I'm not a litigator, I'm a business guy. And everything I say is utter bullshit, and you can't take it as legal advice. All right? That's essentially what it says. I could have just wrote that, but... All right. So I ordered this presentation in order of the most prevalent litigation and enforcement. And the most prevalent litigation enforcement is around fraud and scams, just out and out common law fraud. It's really unexciting and boring because fraud is fraud. So the best thing you can learn from the fraud side of the equation is don't be a fraudster, because it eventually catches up with you. Mathematical minds know that Ponzi schemes and pyramid schemes quickly get to the point where there's not, even with 7 billion people, there's not enough people to sustain those things. So, and then when you get a sudden downturn, that it's even a shorter period of time, and then you no longer love BitConnect. Okay, so the people who are enforcing, and it's sad to say, because the states should be in the United States. By the way, this is a US-based presentation. I wish I had the mental capacity and time to understand more international law, but I just don't. But in the United States, the persons who are enforcing fraud actions are sadly persons who should be enforcing more sophisticated things because the states are lazy and they're not, with the exception, small exception of Texas, and they're not doing their duty of protecting their citizens from fraud. So the biggest one is the SEC. They should be helping to, and they're starting to more, define how real people who aren't fraudsters can operate in the crypto space and do tokenized businesses. But they're having to spend so much time dealing with fraudsters that they're not doing enough in that regard. The next group is the CFTC, which is the commodity, SEC stands for Securities and Exchange Commission. They govern issuances of securities and marketplaces for securities. CFTC is the Commodities Futures Trading Commission. Interestingly, the Commodities Futures Trading Commission does not govern commodities. As the name implies, they govern commodities futures. But The only exception, and it's only been a few years this exception's been around, is if there's fraud in underlying commodities. So if somebody is fraudulently selling you corn labeled as, caramel corn labeled as corn, then they can go prosecute that. So in the case of cryptocurrencies, which the Commodities Futures Trading Commission has defined as a commodity, they're having to enforce a bunch of fraud cases. The Federal Trade Commission also is a consumer protection agency, also trying to bat down all this fraud. And the states, Texas leads the states. So how we have 50 states and one District of Columbia and 4 or 5 or 3 or 4, I can't remember, territories. Texas leads the states and the territories with 2 whole actions. And really, they didn't shut down Arise Bank, which was a Dallas-based fraudster. What they did is they gave Arise Bank a notice that said, hey, you're not really a bank, so don't take Texas deposits. And the jackwagon who was doing Arise Bank wrote back a very indignant letter, which I read and sent to my pals at the SEC's Fort Worth Office of Enforcement. And I said, look, I'm not a great fan of regulators, but you can't treat them like this. So the next week, they shut them down. The SEC did, actually, not the state. So it's just sad that the states aren't doing enough here. But here's the thing about cryptocurrency. It is just a reiteration of old-fashioned pickpocketing, right? Old-fashioned pickpocketing will go up to you. It's actually happened to me in Chicago once. I was walking down State Street. The person will go up to you and start touching you all over the place, and it just confuses your brain. And so they don't even have to be delicate. Right? You don't have to like sneak stuff out of your pocket. You're getting too much sensory input, and they can just take whatever they want. Same with cryptocurrency. There's so much to the regular person, even to some of the technicians. There's so much stuff all around it that they can build a confusing dynamic and defraud you. So, everything old is new again. All right, the next greatest area of litigation. So I really can't tell you a lot to learn from scams other than it's not a particularly good thing to do. With regard to FinCEN, money service businesses, that's what MSB stands for, money laundering. This is the next greatest area of litigation, and probably because it's one of the easiest things to get tripped up on. Since the days of Al Capone, where they actually wrote him and put him in jail permanently because of financial transactions not appropriately reported, in that case tax, governments have learned that they can recruit private enterprises to kind of, which I think is wrong, frankly, but to enforce other laws, right? So it's very easy to prosecute these cases. The FinCEN has determined that any convertible currency, cryptocurrency, is a value transfer mechanism. So unless, this is a lesson you're going to be learning, unless you restrict the use of your cryptocurrency to your own ecosystem, you must comply. And if you allow it to trade, you must comply with registration with FinCEN. You must register with the various states where you operate as a money services business, and you must adopt policies and procedures to know your customer, to have anti-money laundering arrangements, and it's expensive and a pain. But it's not happening a lot, unfortunately. The chickens will come to roost. And by the way, there's a whole other level, speaking of international law, it's called mobile money services regulation. And that arises because in most of the world, people transact over their mobile phones. So it's the same as a money services business in the US, which arose from the days of the telegram, right? When Western Union would send money back and forth. Well, they never got a lot of telegram infrastructure in Africa and China and whatnot, but now they've jumped ahead and they do it off their phones. Mobile money laws. So the dynamics that you see are, so this is history. I got to run through fast, so if anybody wants to get into nitty-gritty, I can do it later. The dynamics you see are personal actors, where I go to Jana at a meetup and I take her dollars personally and I give her Bitcoin. That can be a regulated dynamic. It depends upon the local state. In Texas, it's not. We're kind of lucky, if you don't like regulation, that Texas's money services business law doesn't really cover cryptocurrency because it explicitly says government currencies. There is one minor exceptions, but for the most part, compliance in Texas is not, and a few other states is like that, are not required. So you'll see a little bit of difference. Florida is like that too, where somebody tried to do a sting on me when I was trying to get Jana to do a transaction with me, and then sometimes they're convicted and sometimes they're not. It kind of depends upon the state statute. And you find, interestingly, that most of the convictions actually occur when you're also selling drugs at the same time. So that's the personal dynamic. And the same with the marketplaces, right? We know another great Texan in the crypto space, Ross, how do you pronounce his name? Ulbrich? I saw his mother speak last week. Very interesting and sad. But anyway, because he's given like 2 life sentences plus 40 years. That's pretty harsh. But at the same time, while he was being tried, all his good friends in the crypto world had all kinds of death threats for the judge. So you can imagine her frame of mind when she sentenced him. Anyway, so Ross was, he was also engaging in a transfer of value business, but also facilitating drug sales, right? Same thing. And you can see this, Charlie Shrem, upstanding citizen. And then, of course, there are the more honest dynamics where people are really trying to solve a problem, and they just didn't think about it. So, for instance, Ripple actually started, as you probably know, as not a tokenized business, and some might argue that they don't have a real cryptocurrency now anyway. But before they entered the crypto space, they were trying to facilitate transfers more efficiently to convert currencies, and they got caught up by FinCEN, and they got through it. They came to an agreement, a settlement. I think it paid $750,000. They changed their way of doing business. And basically, they operate under the compliance dynamics of their clients, which are generally banks. So exchanges and others, most of which aren't in the United States because of these reasons, can find themselves with problems in this regard. So the lessons, it's very jurisdictional. What we have with cryptocurrencies is a jurisdictionless dynamic, which means every jurisdiction is implied. It's actually the opposite of jurisdictionless, right? It's jurisdiction full. Everybody touches it. So you need to know what jurisdictions are going to apply with regard to FinCEN, MSB, and mobile money stuff. So an extensive jurisdictional analysis. I have a friend whose sole legal practice is doing this registrations in Canada and the United States. To do a full-blown registration across both countries, about $2 million in 2 years is what it's going to take. And the Perkins and Coie one is not going to be much faster and is going to be twice as expensive. But I love them. Don't get me wrong. So massive number of regulatory bodies. And I've said before, it's the most encompassing regulatory trap. We've got way too much focus on securities laws when this should be paramount to you. I mean, securities laws are important, but and the reason I think that it's not as big a focus is because the dynamic of this area is kind of it's kind of less draconian, really. You just have to pay your fine, and FinCEN isn't being as proactive as we're seeing now the securities people in trying to define the dynamic. Commodities regulation. So I gave you a little preview of this. So basically exchange, which comes within the jurisdictional reach of the Commodities Futures Trading Commission, should be registered with them. And that's a big reason why, for instance, you see, is it Bitfinex that is associated with Tether? So that's why they've gone way offshore, way offshore. They keep going farther and farther away. They're backed into a corner. And they don't accept US investors anymore. Although, if I recollect correctly, the CFTC has delivered subpoenas to them recently and others, regardless of their efforts, because they get in the whole financial chain of things, and they still think they can reach them. Security. Okay, let's go ahead and talk about securities. I first got in this space, so not quite 2 years ago, and it really amazed me and confused me how the people in the space would say, hey, it's not regulated. Right, I mean, I suppose if you rob a bank and you don't get arrested, you're not regulated, right? But we got young technicians who are changing the world, and literally, I hear that. I had a group that came to me, got on call. A friend of mine is with them. They had a $20 or $30 million ICO going on. They had sold about 10 million. They called me and said, we're doing great. We're happy. We're excited. We're going to change the world. We're about 10 million into our ICO. We thought maybe it's time to talk to a lawyer. And so they gave me their facts. I asked them questions, got down to the bottom of it. I said, well, you're breaking all these laws. Let me know. I'll be happy to salvage what we can. I didn't hear from them again. So I think they raised 20 or 30 million. The funny thing, very coincidental, I run something called a blockchain law study group at the Dallas Bar Association, and I didn't have anybody to present. I think it was in August or July, whenever the Dow report came out from the SEC. And I presented we do it at lunchtime. I presented on lunch. That afternoon, this report came out, which said exactly what my securities presentation said. Because any securities lawyer worth a darn would say the same thing as what the SEC said. And in fact, Sonny has my presentation just in case somebody doesn't show up. So I'll give that to you if you're lucky, if you're very lucky. But the Dow was really, the SEC is literally, I've done business now, again, I'm sorry to say it, for more than 30 years as a lawyer and a businessman. And I've dealt with a lot of regulators. The SEC is by far and away the most professional, reasonable, intelligent group of regulators I ever have worked with. I love working with them. And they're very fair, surprisingly. So the reason why they took a year after the Dow to issue this report is because they are sensitive to the fact that everything is legal unless illegal type of jurisdiction, as opposed to Napoleon law or socialist communist law, where everything is illegal unless they permit it. And so they wanted to look at it closely and come out with a very cogent, explicit framework. And the Dow represents, the Dow report, and I'm assuming I don't have to repeat for you the Dow dynamic. If I do, come talk to me later. The Dow report represents the SEC's reasonable stake in the ground. It says, they're basically saying, look, henceforth, we're not going to be letting this go on without your notice that these can be securities. But one thing is, if you're an investor, let's say you have a crypto fund, and you want to invest in ICO-based issued tokens, you have a safer bet with a pre-Dow report investment, because the SEC is unlikely to pursue an enforcement action against those out of fairness. They gave their notice in June or July or August, I can't remember now, when they did. Since that time, the SEC has been, it takes a long time to create explicit regulations. You have to propose the rules. You have to put them out for comment for months. You have to take the comments. You have to synthesize the comments. You have to come out with a new set of rules. You propose it for comments again. So the SEC feels, look, there's no time to do that. So what they're doing now is there's something called regulation through enforcement. They're finding people who are screwing up, and they're writing thorough reports about how they're screwing up to give everybody else guidance. And they're doing what's called cease and desist orders, where they go through very explicitly. They don't have to. They can just say, hey, you violated the law, don't do it again, here's your penalty. But what they're doing is they're going through very explicitly and going through facts and conclusions of law, and then saying, here's your cease and desist order, because they're trying to benefit the space, right? Now, Munchie is the most thorough cease and desist order to date. And basically, what you can learn from that is, number one, get legal advice. And I actually do more business consulting than legal in this space, but I can direct you to somebody who wants to take the risk of providing legal advice. Get legal advice. The Munchie guys actually purported to have gotten legal advice. You might have heard of the Howey test, which maybe I'll describe in a second. But they said in their materials that they had done a Howey analysis and that they were cool. These were not securities. When the SEC asked, hey, give us your Howey analysis, they said, they hadn't done it. And they hadn't talked to legal counsel. And they were changing the world, just like the guys I talked to, so why would anybody get in their way? Also, what you say matters. There's a concept in law called admission against interest, which means if you're being held up for legal liability, civil or criminally, you say something that you admit your fault, you can't unbreak that glass, right? If you are saying, as they did in Munchie, this is going to be a great investment, guess what the Securities Exchange Commission is going to say? You're telling me it's not a security? You're telling me it's a pre-sale of utility tokens, but you're talking about what a great investment it is? Aren't you really saying it's an investment with speculative upside like any other investment instrument in a security? So it matters what you say. Other thing that's really clear is, I don't know if I wouldn't rather just go without a white paper. Because a white paper is a nice piece of evidence against you, which is not well written, doesn't take into account all the stuff you'd want to disclose to an investor, and ends up being your noose. The other thing that the SEC made pretty clear is that the concept of a utility token doesn't save you. So this comes from the Howey test. I'll just describe it real quickly. Howey test is if you raise capital in respect of a dynamic where you are a centralized party and you're going to provide an upside return to the people who give you capital, then there's another test. They kind of blend together. Then you're issuing a security. Howey was actually a sale of orange trees in an orange grove. And the guy was going to manage the orange grove and then give everybody their proportional piece of the return. That was considered an investment contract, which is what part of the definition of a security. So you can see it can be really broad, right? Orange trees, right? You know, the Howey test is, in my estimation, a relatively complex analysis for a simpler time. And in fact, I just heard Dave Hirsch from the SEC's Enforcement Division at a recent conference say basically the following, which I've been saying for a while. A more complex time yields itself to a more simple test. And the simple test is this. Did you raise money with a token? And does a person who buys the token have any reasonable expectation of speculative upside? Now you got a security. Okay. Now, some people, you know, the process now of selling tokens is a lot of people will, okay, I'll admit it's a security, and I'll do an initial. If you have a security, you have to register it with the SEC unless you have an exemption, right? So they'll do an initial sale, either through a simple agreement for tokens or a simple agreement for tokens or equity, which is an interesting evolution. And they'll comply with an exemption, right? And then they'll do maybe a sale of tokens, and they'll comply with an exemption. The exemptions tend to be they're selling only to non-U.S. citizens, called a Reg S exemption, and they're selling to U.S. citizens under Reg D, so they have to be accredited moneyed investors that they confirm are accredited, right? here's the problems with that. Number one, you have forever admitted you're selling a security. Even if I think people are silly to think that they will use tokens and call it a security and try to comply, and then later have a whole token issuance dynamic and say, no, now it's not a security because I added some algorithms to the token dynamic. If you want to take that risk, spend a lot of your life working on that, then that's your choice. The other thing is that the exemptions that people rely on are virtually impossible to comply with in respect of tokens. So for instance, if you do a Reg D to moneyed individuals in the United States, they have to hold that token for at least 2 years. If you do a Reg S to non-US citizens, they can't let that token get into the US system. And as the Massachusetts case here says, we don't care how hard you tried. If it happens, you just busted your exemption. And, frankly, I'm not very smart, but I can use a VPN to hide my IP address and buy a token. So good luck trying to comply in that regard. All right. So is the answer free crypto? And that's what everybody's trying to do right now, right? They're saying, hey, well, if we don't raise capital, then how can you say we're issuing a security, right? And what they're doing is they're creating 1 billion tokens. They're holding 20% back in their founders. They're giving 80% to the company, and they're giving free crypto, and all of a sudden they have an infinite return on the crypto they held, both to the company and the founders, right? Because it's a convertible token and it trades for something, somewhere. So it has some value. Well, guess what? When I opened up this conference, I talked about the fact that this is the latest iteration of a tech boom, and this is so much like the internet tech boom. This was tried already in the internet age. You had companies that had nothing going for them that said, hey, if we can manufacture a trading environment for our stock just by giving it all away, that can't be wrong, can it? I'm sorry, but there's precedent. It's wrong. You're getting, the SEC's analysis was the company is getting valuable consideration in terms of creating relationships and getting information in respect of these persons. And just like they do with crypto now, they're getting a value enhancement to their existing securities. So, it's a box that we're in. Now, I don't care that much about the regulators in this regard. And sadly, neither do most of the ICO and crypto people. Because they say, Constantine in particular, because he looks like he's in great shape, they say, if Constantine says, Jerry, if you and I go to the woods, look, I'm 20 years younger than you, maybe 30, and you got a bad back and you're a little overweight, and we find a bear, and Constantine says to me, you know what, you're dead, Jerry. I'm alive. I'm running faster than you. Well, let me tell you, there's one SEC. There's 52 or 3 or 4 U.S. jurisdictions, states and D.C. and territories, all of which have their own basically similar securities laws. But more important than that, tort reform has made the bears of the plaintiff's bar very hungry. And there are private rights of action under our securities laws in the United States. I don't think it's the case in other jurisdictions, but I'm a U.S. lawyer. And those hungry bears number in their hundreds of thousands. So Constantine, when you and I go in the forest and we encounter several 100,000 bears who are very, very hungry, who's going to survive? Probably the bears will start eating each other after they eat us because they're hungry. And that is probably going to happen. And the plaintiffs' lawyers are going to be all over each other trying to be the one leading class actions in this space, literally like the hungry bears. And there already are some class actions out there. There's a firm in Florida kind of specializing in this. I know, since I'm in the financial fund business and I have a lot of pals in it, I already know of people creating private equity funds to fund this litigation. It's not going to be hard. That's why I think this fall, is when you're going to have a high probability, at least 50% chance of a whole crash here. Because when the scales fall off the eyes and they realize that it's all effed up, hey, blink that out. The market's going to die, right? By the way, the SEC issued its enforcement priorities a couple weeks ago. On there, of their 6 or 7 priorities, was cryptocurrency, but more importantly, market regulation of cryptocurrency, which nobody talks about. All right, so securities overview, scams are scams. Honest folks need to be more careful. They need to cease being naive. They need to cease thinking that just because you can go on WebMD, you're a physician, and just because you can look up statutes, you're a lawyer. Law and human life, and I love engineers, and I love technicians, I love coders, but coding and rules-based systems are not consistent with how humans live. They pour a bunch of gloss over things, and hyper-technical, highly assured belief that you've read statutes correctly is a recipe for disaster. And frankly, I'm tired of putting my 35 years of securities law practice up against 25-year-olds. You just got to give up. And hubris. I mean, that's the 25-year-olds. Howey's 4-part analysis I've mentioned is deceptive and itself over-technical. It's a creature of simpler times that I've mentioned. Current complexity yields simpler analysis. Oh, I'm the last one, so I can go as long as I want.
And it's interesting. You can.
Yeah. So I was an English major, so this title makes me laugh, right? Securities, future imperfect, you will have arrived. So the future perfect tense is saying something that exists now in the future. You will have arrived. Anyway, so where will you have arrived with all of this? I don't know. Where you will have arrived is that you have to start looking at the fact that the SEC is going to get in the shorts of all the... So the SEC is enforcing 2 statutes, well, more than 2, but in this regard, 2 statutes. The other fellow mentioned the 40 Act, but the 33 Act governs the issuance of securities and how you do it properly. The 34 Act governs the creation of a fair and honest and reliable market. As anybody who is in the crypto space knows, that is a far from what the market is in crypto. It's entirely unfair. People are jobbing it all the time. And they've announced, as I mentioned before, that they're going to get on this. So expect not only ICO statements from the SEC and enforcement, but cryptocurrency investment fund regulation and exchange regulation. I'm going to quickly go with a few other things. When I first started practicing, again, when dinosaurs roamed, the securities lawyers were very, very careful. It's because just prior to that, there had been a similar time to now when securities lawyers were not being very responsible. And so the then, I think his name was Levitt, SEC commissioner, actually announced an effort to create gatekeeper liability in securities lawyers, which is kind of weird because in the United States, a lawyer can help you break the law. I mean, they're the other half of your brain, right? They're not supposed to have liability for that. Where at least they can tell you what the law is and they don't have to stop you from breaking it. Anyway, that made everybody practice extremely carefully. A couple weeks ago, the SEC commissioner brought up the specter of gatekeeper liability again. And it's not just securities lawyers, it's accountants, it's exchanges, it's fund people. They're going to start looking beyond just the issuers. So I'm not going to say much more about that. A few other areas. This makes me sound like I'm not a crypto fan or a blockchain fan. I am a huge fan of it. A huge fan. And I'll tell you what's going to happen. And it's going to be with us for the what was it in Casablanca? Now and for the rest of our lives, something like that. Anyway, there's other litigations. Now it's a thing, right? So there's all kinds of litigation about asset division, whether in bankruptcy or divorce or whatnot. The whole contract dispute thing is coming down the pike in all kinds of ways. Interestingly, a Ninth Circuit case against Coinbase said Coinbase couldn't rely on their arbitration provisions. The Ninth Circuit hates arbitration provisions unless it involves industries that are prominent in California. A very strict legal analysis. That was supposed to be kind of funny. So they invalidated this because the English-speaking person who wanted to avoid the arbitration clause, actually his primary language was kind of something like Russian or something. And they said, well, you didn't provide it to him in Russian. So they invalidated it. And then cyber issues, right? We got hacks all the time, and there's all kinds of liability coming down the pike in this regard. You got folks trying to put mining software on your computers and your phones. All this is coming down. Okay, let's get to the overarching lessons. And then Farheen can bring out her hook. Jurisdictionless means jurisdiction full. There's tons of overlapping regulators and jurisdictions. So, frankly, somebody who's been both a business lawyer for 30 years and an entrepreneur for 20 years is maybe a great guy to talk to about this, but not me. Full realization of this dynamic requires a global solution. But the global solution isn't going to be through the UN. So consider not using tokens to raise capital. Consider building a very special, differentiated, tokenized business and keeping it within the system. That'll be very much like existing quite legal operations, like reward systems or what are the cards called that people give you and then you never spend the money on them because they're only used at one place? Gift cards. And gift cards, because there's no speculative upside in those, right? Now, maybe later when regulation is more kind of known, you can let them trade. But for now, save your business. You need to be, and that's what I call kind of regulatory jujitsu. Use known paradigms that work. You have to be thinking ahead. You have to skate to where the puck is going. Not to, if we were, I couldn't understand why people were saying there was no regulation because they were skating where the puck was back then, right? They weren't thinking about where things are going. This is an area where subject matter innovation must be married with legal innovation. I call my URL for my law firm is swordshieldlaw.com because I view the law as something to use to advance the mission while protecting its flank. So you must do it here. You don't really have a choice. Don't be short-sighted. Don't be short-termism. Plan to build a business for the future and don't think just because you're a good guy with reasonable efforts is going to save you. Another big one is look, once you do a few decades of business, you realize if you cause problems for your business partners, they become your problems. I told you I already know law firms are actively looking to get all your tokens. So all your tokens belong to us, they're going to be saying. And so, as I said before, either don't use tokens to raise capital, use it for some other really fantastic dynamic in your business, or be prepared with strong defenses. And if you're Constantine, set up an irrevocable trust and put all your assets in there so no creditor can get to it. I mean, there's things you can do if you have a wise way of looking at it. At the end of the day, sow brain, much damage. Okay? I think I have about an hour for questions. Okay?
Can you talk loud? Thank you, Jerry. That was great. Hold on.
Regarding the subpoena for Bitfinex, do you think if it reaches the Bitfinex, would Tether crash?
Yeah, Bitfinex is also one of the things that will crush the space.
And
Their dynamic with Tether, which I'm sure you've read enough about it. Tether is a supposed substitute for U.S. dollars and is used to notionally prop up the dollar value of Bitcoin and other tokens. It's gonna face the problem of geometrical progression, right? And it's close.
What's stopping the subpoena to reach Bitfinex?
What's what?
What's stopping the subpoena to reach Bitfinex?
Why isn't it collapsed yet?
Yeah.
Because when a pyramid or Ponzi scheme is being operated, nobody wants it to stop. That's why. Everybody's invested in it. Everybody at Coinbase is invested in it. Everybody in every place is invested in it. When it crashes, everybody wants the regulators to take care of them. Until then, they want the regulators out of their business.
Okay, any more?
I mean, obviously, it's not just law, it's humanity.
So I've thought that there might be some sort of a crash, like the .com crash, but you feel very sure of it. What I'm curious about is whether you feel it will be like the .com crash, in which there will be a few very strong survivors, Amazon's.
I promised. I'm sorry, Constantine left. I promised to tell you what's going to happen. Okay, here's what's going to happen. Number one, unlike the last crash in 2008, where, frankly, my more than $11 billion AUM real estate business got killed, there's going to be people going to jail, but more than that. And by the way, they didn't go to jail in the last crash because everybody was operating under known paradigms of legal behavior, right? In fact, the government was complicit. They actually caused the crash, and they created those paradigms. In this dynamic, people are acting in wacky paradigms that haven't ever existed, very easy to attack, and very easy to put people in jail. But more than that, the anonymous possibilities of cryptocurrency investors will result in a lot of mortal harm when the crash happens. Look, I didn't mention this before, but and again, I've had businesses. The last thing I'd ever want would be anonymous investors, right? Like I said, in the last crash, I actually got to participate in both the last crashes, both my telecom company and my real estate company. But the last crash, I know that some of our investors, I had 200,000 investors in real estate funds. I know a good proportion of them went to bed every night wanting to kill me. But they were all identified, right? And honestly, I felt very bad. I didn't want these bad things to happen to them, but what can I do against a tsunami of, total correlation of all assets going downhill by 40% in value? In any event, the people who want to kill you in this space can and do kill people. And the only people that are identified in an ICO are the founders. But what will happen, what will come out of the ashes is this. Think about it. It's a global, jurisdictional dynamic. And cryptocurrency and tokenization is really fascinating. In fact, that may be the only really differentiated value of DLT blockchain. But it's cool value. In the 1600s, they created joint stock companies, later called corporations, which created for the first time another layer of currency beyond money, equity. Now we have a third layer of currency and liquidity. So that's huge value. Well, what's going to happen? Well, who's going to be poised to take advantage of this? Global public companies. You're going to have currencies sponsored by Facebook, by Google, by Amazon, by Apple. And all they have to do is fold it into their already existing and reporting securities law dynamic. They're already global compliance departments. It's going to be so easy. That's what's going to happen. And by the way, the New York Stock Exchange and all the other existing exchanges will take over the exchanges of currencies. Why not? They got all the regulatory compliance, and they've got all the reliability, and the regulators like them. So that's what's going to happen. So to you innovators and pioneers, keep doing it and position yourself to be the experts that those companies need. Anything else?
Excellent.
Yeah. One more? Shout. That doesn't help. Using the nonprofit structure as a canard.
I know the nonprofit may not be really like shield from the regulations, but make litigation very difficult because it's a nonprofit, so there are not money there. You can litigate it, but there is no money. So that's one. The second one is.
Whoa. Why do you think there's no money at the nonprofit? They just took in a bunch of currency.
No. For example, there are different ways, right? I think people.
Well, okay. Let me just make clear the liability in this space.
How to get around.
Let me make something clear that might change the way you're thinking about it. The liability in this space is personal liability to all of the directors, officers, and promoters, which is a very broad term. It can even include your accountants and lawyers.
Sometimes it's because because you mentioned the DAO, right? But I think it requires more discussion of that. Because in the case of DAO, it's more, if you don't do really like ICO, the DAO is more like a cyberspace partnership. So from litigation perspective, I feel like it's very, very difficult. Even
Am I encountering another 25-year-old telling me what securities laws is?
No, I'm not trying. I'm just saying it's difficult to regulate, right? So. Yeah, because.
All right. We have to wrap it up.
All right.
We have to wrap it up. So
Let's go have a
thank
drink.
you very much.